Hi guys, welcome back to my channel. Maayong hapon. It's been a long time since I have uploaded a video lecture in my channel. I've been really busy with, motherhood and all the other professional commitments and personal commitments. And I'd like to thank, of course, my subscribers. Daghang salamat for the support as always. I am now on my 15,000 subscribers na tayo plus. I hope that you guys will help me reach 20,000 this year. That's my goal this year, to reach 20,000 subscribers. And maraming salamat sa lahat ng inyong mga comments, very kind comments. I'm sure some of you are having a hard time understanding some of my lectures because I've been speaking vernacular. In this lecture this morning, I would try my best. I will try my best to come up with a lecture na maiintindihan ng lahat. So, ngayon ang ating topic ay continuation ng ating previous topic ng criminal procedure, which is bail. Okay? Ano ba yung bail? What is bail? Bail is the security according to Rule 114, Section 1. Bail is the security given for the release of a person in custody of the law furnished by him or by a bondsman. Okay? So, pwede na this will be furnished by him. Okay? Pwede na siya, meaning siya mismo ang magbabayad or magpo-provide ng kanyang bail, or by a bondsman, okay? To guarantee his appearance before any court as required under the conditions hereinafter specified. Ang bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Ito, we will be discussing this one by one later on when we reach the part wherein dinidiscuss yung definition ng corporate surety, property bond, cash deposit, or recognizance. Okay? So again, ang bail is a security given for the temporary release of a person who has been arrested. Okay? Diba? Sabi, in custody of the law. So, okay? Meaning, he has been arrested but whose guilt has not yet been proven in the court beyond reasonable doubt. Okay? Ang bail in the case of Enrile versus Sandigan Bayan is not granted to prevent the accused from committing additional crimes. The purpose of bail is to guarantee the appearance of the accused at the trial. Okay? The reason why there is a bail is to ensure that the accused will appear during the trial. Okay? Now, you might be asking, meron bang basis ang bail in the Constitution? Why are persons whose custody is under the law allowed to post bail? Itong right ba ito ay constitutional? Basically, the right to bail is a constitutional right, okay? And empathically, the Philippine Constitution provides that all persons, except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. That's provided for in your Article 3, Section 13 of the 1987 Constitution. Ang right to bail basically emanates from the accused's constitutional right to be presumed innocent. It is accorded to a person in custody of the law who may, by reason of the presumption of innocence he enjoys, be allowed provisional liberty upon filing of a security to guarantee his appearance before any court. Okay? Again, in the case of Enrile versus Sandigan, sabi ng Supreme Court, this presumption of innocence is rooted in the guarantee of due process and is safeguarded by the constitutional right to be released on bail and further binds the court to wait until after trial to impose any punishment on the accused. Okay, now the Constitution lays down the following fundamental tenets on bail. Okay, sabi ng Constitution, all persons charged before their conviction, um, for a criminal offense shall be entitled to a bail. Okay? Ito yung general rule. This is the general rule. Lahat ng tao, if you are charged with a criminal offense, prior to your conviction, you are entitled to a bail. Okay? And the suspension of the privilege of writ of habeas corpus does not impair the right to bail. Okay? An excessive bail is not to be required. And then the constitutional provision on bail is substantially reiterated in the rules of court, particularly in Section 7 of this rule, okay? Sabi ng Section 7, no person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment should be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Okay? So taking into consideration the Constitution and the rules of court together, the rule is therefore that a person shall, before conviction, be accorded the right to bail. Okay? Unless, okay, remember this, lahat ng mga tao charged with an offense before conviction are entitled or afforded the right to bail, unless the exception is if charged siya with a capital offense or an offense punishable by reclusion perpetua or life imprisonment, and may and yan, and the evidence of guilt is strong. Okay? Ano yung general rule? Yung general rule, all persons charged before conviction of a criminal offense, you are entitled to post a bail. Except lang kung you are charged before conviction, you are charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment, and the evidence of guilt is strong, the bail here will not be granted. Okay? The grant or denial of bail to a person charged with an offense punishable by at least reclusion perpetua or life imprisonment is made dependent on whether or not the evidence of guilt is strong. Okay? The rule, for instance, applies to a rape case, di ba? Or a co-data, since both are punishable by reclusion perpetua. So no distinction is made as to the political complexion of or moral turpitude involved in the crime charged, okay? The test is not whether the evidence establishes guilt beyond reasonable doubt, but rather whether it shows evident guilt or great presumption of guilt, okay? As such, the court is ministerially bound to decide which circumstances and factors are present which would show evidence of guilt or presumption of guilt. Okay? Under the rules of court in Rule 133 of Section 2, proof beyond reasonable doubt is the quantum of evidence necessary for conviction, not to forfeit the constitutional right to bail, which merely requires the evidence of guilt be strong. Okay? Evidently, strong does not mean proof beyond reasonable doubt. Okay? So remember, na if you are charged with a capital offense, or if the offense charged against you is punishable by reclusion perpetua or life imprisonment, kailangan, before a bail is denied, the evidence of guilt has to be strong. But it does not mean that you are already proven or your guilt is already proven beyond reasonable doubt. Okay? So, we will be discussing that thoroughly later on sa ating mga subsequent na slides, okay? But basically, initially, you have to remember na ang bail, as a general rule, before conviction, sa hindi pa nakukonvict an accused, ito ay karapatan mo, okay? This is a right. Except, kahit na before conviction, even if wala pang conviction, if ang iyong kaso that of a capital offense or an offense which is punishable by a reclusion perpetua or life imprisonment, and there's an and there, okay? And the evidence of guilt is strong, yung karapatan ng isang tao to post a bail will not be accorded, okay? Or will not be given to him, okay? Now, is there a bail in the military, okay? According to the case of Comendador versus Villa, the right to bail has traditionally not been recognized and is not available in the military as an exception to the general rule embodied in the Bill of Rights. The right to a speedy trial is given more emphasis in the military where the right to bail does not exist, okay? The unique structure of the military should be enough reason to exempt military men from constitutional coverage on the right to bail. The argument that denial from the military of the right to bail would violate the Equal Protection Clause is not acceptable. This guarantee requires equal treatment only of persons or things similarly situated and does not apply where the right of the treatment is substantially different from others. Accused officers can complain, this is the case of Comendador, accused officers can complain if they are denied bail and other members of the military are not. But they cannot say that they have been discriminated against because they're not allowed the same right that is extended to civilians, okay? Now, there's also this issue on extradition proceedings, okay? Is there a right to bail in extradition proceedings? In the case of government of the United States of America versus Purganan, one of the issues presented for resolution was whether or not a person facing extradition is entitled to bail. The private respondent maintained that the Philippine Constitution secures the right to bail of all persons, including those sought to be extradited. The only exception being a person who is charged with an offense punishable with reclusion perpetua when evidence of guilt is strong. He also maintained that the granting of bail would, among others, be consistent with Section 4 of Rule 114 of the Rules of Court, which provides when bail is a matter of right. On the other hand, the petitioner claims that there is a provision in the Constitution granting the right to bail to a person who is the subject of an extradition request and warrant of arrest. The court agreed with the petitioner and advanced the following reasons. Sabi ng Supreme Court, the use of the word conviction in the constitutional provision on bail in Section 13, Article 3 of the Constitution, as well as Section 4 of Rule 114 of the Rules of Court suggests that bail applies only when a person has been arrested and detained for violation of the Philippine criminal laws. It does not apply to extradition proceedings because extradition courts do not render judgments of conviction or acquittal. The constitutional right to bail flows from the presumption of innocence in favor of every accused who should not be subjected to the loss of freedom, as thereafter he would be entitled to acquittal unless his guilt be proved beyond reasonable doubt. It follows, ruled the court, that the constitutional provision on bail will not apply to a case like extradition where the presumption of innocence is not at issue. Extradition proceedings are not criminal in nature but sui generis, a class in itself. Since it is not a criminal procedure, it will not call into operation all the things of an accused under the Bill of Rights and does not involve a determination of guilt or innocence. The court, however, did not hold that bail never applies to extradition cases. Instead, the court explained that bail is not a matter of right in extradition cases. However, the judiciary has the constitutional duty to curb grave abuse of discretion and tyranny, as well as the power to promulgate rules to protect and enforce constitutional rights. Furthermore, the right to due process is broad enough to include the grant of basic fairness to extraditees. Indeed, the court stressed that the right to due process extends to the life, liberty, and property of every person. It is dynamic and resilient, adaptable to every situation, calling for its application. But there are some exceptions to the no bail rule in extradition proceeding. In establishing an exception to the no bail rule, the court in the government of the United States of America versus Purganan raciocinated that according and to best serve the ends of justice, we believe and so hold that after a potential extraditee has been arrested or placed under the custody of the law, bail may be applied for and granted as an exception only upon a clear and convincing showing that once granted bail, the applicant will not be a flight risk or a danger to the community, and that there exist special, humanitarian, and compelling circumstances, including, as a matter of reciprocity, those cited by the highest court in the requesting state when it grants provisional liberty in extradition cases therein. Since This exception has no express or specific statutory basis, and since it is derived essentially from general principles of justice and fairness, the applicant bears the burden of proving the above two-tiered requirements with clarity, precision, and emphatic forcefulness. The court realizes that extradition is basically an executive, not a judicial responsibility arising from the presidential power to conduct foreign relations. In its barest concept, it partakes of the nature of a police assistance among states, which is normally a judicial prerogative. Hence, any intrusion by the courts into the exercise of this power should be characterized by caution, so that the vital international and bilateral interest of our country will not be unreasonably impeded or compromised. In short, while the court is ever protective of this sporting idea of fair play, it also recognizes the limits of its own prerogatives and the need to fulfill international obligations. However, 5 years after Purganan was decided, on April 19, 2007, in the case of Government of Hong Kong Special Administrative Region versus Eulalia, the court ruled anew on the issue of whether or not bail applies to extradition cases in a petition which assailed the order of the RTC of Manila granting bail to a person subject of extradition proceedings. While admitting that the ruling in the previous case of U.S. government versus Purganan falls squarely to the private respondent's case, the court in Hong Kong versus Eulalia viewed the issue in the light of modern trend in international law, placing primacy on the worth of the individual person and security of human rights. Naingon ng Supreme Court, according to the Supreme Court, it cannot ignore the growing importance daw of the individual person in public international law, who in the 20th century has gradually attained global recognition, and the higher value now being given to humanitarian rights in the international sphere. The corresponding duty of countries to observe these universal human rights in fulfilling their treaty obligations, and the duty of the court to balance the right of the individual under our fundamental law on one hand and the law on extradition. Okay? In re-examining Purganan, sabi ng Supreme Court, it made the following observation. Sabi nila, first, that the exercise of the state's power to deprive an individual of his liberty is not necessarily limited to criminal proceedings. Respondents in administrative proceedings such as deportation and quarantine have likewise been detained. Second, to limit bail to criminal proceedings would be to close our eyes to our jurisprudential history. Philippine jurisprudence has not limited the exercise of right to bail to criminal proceedings only. This court has admitted to bail persons who are not involved in criminal proceedings. In fact, bail has not been allowed in this jurisdiction to persons in detention during the pendency of administrative proceedings, taking into cognizance the obligation of the Philippines under international conventions to uphold human rights. Noting that bail had in the past been granted in deportation cases, the court reasoned that if bail can be granted in deportation cases, then it sees no justification why it should not also allow in extradition cases. Likewise, sabi ng Supreme Court, considering that the Universal Declaration of Human Rights applies to deportation cases, there's no reason why it cannot be invoked in extradition cases. For after all, both are administrative proceedings where the innocence or guilt of the person detained is not an issue. Clearly, sabi ng Supreme Court, the right of the prospective extraditee to apply for bail in this jurisdiction must be viewed in the light of various treaty obligations of the Philippines concerning respect for the promotion and protection of human rights. Under these treaties, the presumption lies in favor of human liberty. Thus, the Philippines should see to it that the right to liberty of every individual is not impaired. Okay? So, yan na ang naging pananaw ng Supreme Court recently after the Purganan case. And this is what they said in the case of Hong Kong versus Eulalia. Okay, so to continue, let's now proceed to Section 2 of Rule 114. Okay? Conditions of the bail. So what are the requirements? Okay. All kinds of bail are subject to the following conditions. First, the undertaking shall be effective upon approval and unless cancelled, shall remain in force at all stages of the case until promulgation of judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to. The accused shall appear before the proper court whenever required by the court of these rules. The failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such case, the trial may proceed in absentia, and the bondsman shall surrender the accused to the court for execution of final judgment. The original paper shall state the full name and address of the accused, the amount of the undertaking, and the conditions herein required. The photographs, kanang passport size, taken within the last 6 months, showing the face, the left and the right profiles of the accused must be attached to the bail. Okay? So, ano ba yung mga obligations and rights ng bondsman? Can there be an arrest without a warrant? Okay. Now, the bondsman shall surrender, according to this section, the bondsman shall surrender the accused to the court for execution of the final judgment. And for the purpose of surrendering the accused, the bondsman may arrest him or, upon written authority, endorsed on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of subtle age and discretion. Also remember that in Section 23, an accused released on bail may be rearrested without the necessity of a warrant if he attempts to depart from the Philippines without the permission of the court where the case is pending. You have to remember, no, when you become lawyers, yung mga clients niyo na naka-bail, di sila pwedeng mag-leave ng court if they are on a temporary liberty because they posted a bail. They cannot go out of the country without the permission of the court. Kailangan silang mananghid. What is mananghid? Magpaalam muna sa court, okay? In the case of US versus Addison, the authority of the bondsman to arrest or cause the arrest of the accused springs from the old principle that once the obligation of the bail is assumed, the bondsman or surety becomes the jailer of the accused and is subrogated to all the rights and means which the government possesses to make his control over him effective. Okay? Also remember that yung applicant for bail must be in custody. Okay? Bail, as defined, diba, earlier in Section 1, is the security given for the release of a person in custody of the law. So based on this definition, the accused must be in custody of the law or otherwise deprived of his or her liberty to be able to post bail. Because, diba, a free man is not entitled to bail. A fugitive may not apply for bail unless he gives himself up first, so he may be placed under the custody of the law. As bail is intended to obtain or secure one's provisional liberty, the same cannot be posted before custody over him is acquired by the judicial authorities, either by his lawful arrest or voluntary surrender. For in the case of Badaranga versus Court of Appeals, sabi ng Supreme Court, it would be incongruous to grant bail to someone who is actually free. Okay? And it would also be equally incongruous, sabi ng Supreme Court, to file a petition for bail for someone whose freedom has not been or has not yet been curtailed. Okay? So, an application for admission to bail by one who is at large is premature. Okay? Ano ba yung rationale behind this rule? Ang reason ng Supreme Court is to discourage and prevent the practice where ang accused magsisend lang ng other person, di ba, on his behalf to post his bail without recognizing the jurisdiction of the court by his personal appearance. Kaya kailangan, before someone can actually post a bail, he should either be arrested or he has to voluntarily surrender to the custody of the law, okay? So now, ano naman yung magiging effect of failure to appear at the trial, okay? Makikita dito sa conditions of bail na the failure of the accused to appear at the trial without justification despite due notice shall be deemed a waiver of his right to be present and trial may proceed. Also, the bondsman may arrest the accused for the purpose of surrendering him. Yung bondsman din, yung bondsman, usually yun yung yung surety bond, nung nagpo-post ng surety bond, okay? The bondsman may also cause the accused to be arrested by a police officer or any other person of suitable age or discretion upon its written authority endorsed on a certified copy of the undertaking, okay? Also, isa din itong napakagandang principle na kailangan nating tandaan, no? Na yung court, hindi supposedly it cannot require arraignment before the grant of bail, okay? This is what the Supreme Court said in the case of the Vides versus Court of Appeals, okay? The court was asked to resolve the issue on whether or not an accused must first be arraigned before he may be granted bail, okay? And then the accused therein assailed the trial court's imposition of the condition that he should first be arraigned before he is allowed to post bail. It was held in this case that the grant of bail should not be conditioned upon the prior arraignment of the accused, okay? In cases where bail is authorized, bail should be granted before arraignment. Otherwise, the accused will be precluded from filing a motion to quash, which is to be done before arraignment. If the information is quashed and the case is dismissed, there would be no need for the arraignment of the accused. All right. Now, the court explained that to condition the grant of bail on his arraignment would be to place him in a position where he has to choose between filing a motion to quash and thus delay his release, or and foregoing the filing of the motion to quash so that he can be arraigned at once and therefore be released. Diba? So nakita niyo yung scenario. So itong mga scenario nito, sabi na Supreme Court, this will undermine the accused constitutional right not to be put on trial except upon a valid complaint or information sufficient to charge him with a crime and his right to bail. All right? So take note of that. Now, Section 3, it provides that no release or transfer except in court order or bail. So no person under detention by legal process shall be released or transferred except upon order of the court or when he is admitted to bail. This is self-explanatory. Ito yung exciting na part, no? Section 4. Sabi ng Section 4, so when is bail a matter of right and what are the exceptions? Earlier, we have discussed in passing, no, regarding this principle. So under Section 4, all persons in custody shall be admitted to bail as a matter of right with sufficient sureties or released on recognizance as prescribed by law or this rule. Una, before or after conviction by the Metropolitan Trial Court. Okay, let's highlight this, before and or after conviction by the MTC, Municipal Trial Court in cities, or Municipal Circuit Trial Court. Basically, doon sa lower court, okay? In the MTC, before after conviction, meaning the crime or the offense charged, the imposable penalty for the offense charge is below 6 years, okay? So if that's the offense charged against a person, yung right niya to bail or yung pag-post niya ng bail is a matter of right before or after conviction. Okay? Before or after conviction. Remember that. Second is, ito, before conviction by the regional trial court of an offense not, klaro yan, not punishable by death, reclusion perpetua, or life imprisonment. Okay. Balikan natin yan. Kailan ba a matter of right ang bail? Bail is a matter of right. Ano yun? Una, before or after conviction in the MTC. Pangalawa, before. Before lang yan, okay? Before conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. Meaning, di mga capital offenses. Okay? So, the general rule is that all persons in custody shall be admitted to bail as a matter of right. Yun yung general rule. Sinasabi natin yan kanina, diba? And as a result, all criminal cases within the competence of the MTC are bailable as a matter of right because these courts have no jurisdiction to try cases punishable by death, reclusion perpetua, or life imprisonment. Because earlier, sabi ko, yung mga offenses lodged before the MTC ay yun namang mga offenses punishable with less than 6 years, di ba? Likewise, bail is a matter of right prior to conviction by the RTC by any offense basta hindi siya punishable by death, reclusion perpetua, or life imprisonment. Okay? Therefore, kailan magiging right to bail or matter of right ang pag-post ng bail? Una, before conviction in the MTC. Pangalawa, after conviction in the MTC. And yung pangatlo is before conviction by the RTC provided na yung offense is not punishable by death, reclusion perpetua, or life imprisonment. Okay? So ano ba yung example? Example, kung si X will be accused of homicide, entitled siya to, saan naman yung homicide, di ba? So, this is just reclusion temporal. So, he is entitled to post a bail as a matter of right before his conviction since his penalty under Article 249 of the Revised Penal Code is only reclusion temporal. And if he is convicted, his admission to bail becomes discretionary on the court. Okay? Another example, itong si X accused of parricide, okay? Or murder, okay? Parricide or murder. Will his right to bail be a matter of right? Okay? It will not be a person accused of parricide or murder shall not be entitled to bail kung ang evidence of guilt niya is strong because ang offense ng mga ito ay punishable na yung reclusion perpetua. That accused, if that accused will be charged with parricide or murder, since this is these crimes are punishable by reclusion perpetua, you have no your opportunity or right to post a bail is not a matter of right but a matter of discretion. Okay, it's a matter of discretion which will be discussed in the subsequent rule. Okay, so what will be the remedy if the petitioner is denied the right to bail? Okay, the remedy of the petitioner from the order of the trial court denying application for bail is to file a petition for certiorari if the trial court committed grave abuse of discretion amounting to excess or lack of jurisdiction in issuing the said order. Certiorari is a remedy to annul the order of the court denying petition for bail. Mandamus may at the same time be availed of to compel the grant of bail, which is a matter of right. When bail is a matter of right, the court is left with no discretion but to grant the same. Okay? When bail is a matter of right, it cannot be denied by the court. Kasi karapatan mo yan. The moment an information is filed against you, makikita mo na bail recommended is this. And the court cannot say you have no right to apply for bail or post a bail because karapatan mo yan, okay? The probability that the accused will escape or not appear in the trial is not a ground for denial of the right to bail. It is, however, a reason for the court to increase the bail bond to assure his appearance. Thus, it was ruled that when a bail is a matter of right, the existence of a high degree of probability that the defendant will abscond confers upon the court no greater discretion than to increase the bond to such an amount as would reasonably tend to assure the presence of the defendant when it is wanted. Such amount to be subject, of course, to the provision that excessive bail shall not be required. Okay, but the court can never say na, oh, you are not allowed to apply for bail because you are a flight risk. The court cannot do that because bail here is a matter of right. Okay, so kailan naman natin masasabi na bail is a matter of discretion? Okay, let's just go through section 5. Upon conviction in the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. Okay? So, if you can remember earlier in section 4, we've said that before conviction in the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, bail there is a matter of right. Okay? Pero, if you are convicted in the RTC of an offense not punishable by reclusion perpetua, death, or life imprisonment, your admission to bail becomes discretionary. So it doesn't mean na kung convicted ka na sa RTC for an offense not punishable by death, reclusion perpetua, or life imprisonment, hindi ka na makakapost ng bail, okay? Because here, admission to bail is discretionary, okay? The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application of bail can only be filed with and resolved by the appellate court. Okay? Now, should a court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail, subject to the consent of the bondsman. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon a showing by the prosecution with notice to the accused of the following or other similar circumstances. Kung si accused is a recidivist, quasi-recidivist, habitual delinquent, or has committed a crime aggravated by circumstance of reiteration, that he has been previously or that he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification, that he committed the offense while under probation, parole, or conditional pardon, that the circumstances of his case indicate the probability of flight if released on bail, that there is undue risk that he may commit another crime during the pendency of the appeal. The appellate court may, motu proprio or on motion of any party, review the resolution of the regional trial court after notice to the adverse party in either case. Okay? So, kailan ba ang bail a matter of discretion? Okay? Bail is a matter of right, di ba? Sabi natin earlier, before conviction of the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. But if ang accused convicted na in the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, the admission to bail now becomes discretionary. Okay? And since the grant to bail is a matter of discretion, there has to be a hearing to be conducted whether or not the prosecution refuses to present evidence, and the prosecutor must be notified to require him to submit his recommendation. This notice of hearing applies in all cases whether bail is a matter of right or a matter of discretion. Now, if the grant of bail becomes discretionary when the accused has been convicted in RTC of an offense not punishable by DRL, or death, reclusion perpetua, or life imprisonment, it follows that if the penalty imposed is death, reclusion perpetua, or life imprisonment, bail should be denied because this means that evidence of guilt against him is not just strong. His guilt has actually been proven beyond reasonable doubt. Okay? Okay? So, in the early case of People versus Nietzsche, sabi na Supreme Court, if an accused is sentenced to suffer reclusion perpetua, his conviction clearly imports that the evidence of guilt is strong. So, di na siya makakapag-post ng bail, okay? The clear implication, therefore, is that if an accused who is charged with a crime punishable by reclusion perpetua is convicted by the trial court and sentenced to suffer such a penalty, bail is neither a matter of right on the part of the accused nor of discretion on the part of the court. In such a situation, the court would not have only determined that the evidence of guilt is strong, which would have been sufficient to deny bail even before conviction, it would have likewise ruled that the accused's guilt has been proven beyond reasonable doubt. Bail must not then be granted to the accused during the pendency of his appeal from the judgment of conviction. Okay? Further, sabi ng Supreme Court, it is a misconception that when an accused is charged with a crime of murder, he is not entitled to bail at all, or that the crime of murder is non-bailable. The grant of bail to an accused charged with an offense that carries with it a penalty of reclusion perpetua is discretionary on the part of the trial court. In other words, the accused is still entitled to bail, but it is not a matter of right, okay? Instead, it is discretionary and calls for a judicial determination that the evidence of guilt is not strong in order to grant bail, all right? The prosecution is accorded ample opportunity to present evidence because, by the very nature of deciding applications for bail, it is on the basis of such evidence that judicial discretion is weighed in determining whether the guilt of the accused is strong. Okay? remember na, di ba, earlier, sabi natin, before conviction in the RTC for an offense not punishable by death, reclusion perpetua, it's a matter of right. Pero upon conviction, it becomes a discretion. But does it mean that if you are charged with an offense, punishable by death, reclusion perpetua, or life imprisonment, altogether, hindi ka na pwede makakapag-bail? Sabi ng Supreme Court, no. It becomes a discretion, okay? But provided that the evidence of guilt is not strong, okay? So if you are before conviction in the RTC for an offense punishable by death, reclusion perpetua, or life imprisonment, and if the evidence of guilt is strong, you can actually post a bail as a matter of discretion. Okay, I hope I am clear in that area. Okay, let's now proceed to the definition of capital offense. What is capital offense? In your section 6, it says capital offense is an offense which, under the law existing at the time of its commission and of the application of admission to bail, may be punished with death. Okay, capital offense, punishable by reclusion perpetua or life imprisonment, not bailable. No person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Ito yung sinasabi ko earlier, okay? When the evidence of guilt is strong, you cannot be admitted to bail, okay? Now, what is the burden of proof in bail application? At the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden of showing the evidence of guilt is strong. Okay? Ng burden nasa prosecution to show that the evidence of guilt of the accused is strong. Okay? The evidence presented during the bail hearing shall be considered automatically reproduced at the trial. But upon motion of either party, the court may recall any witness for additional examination unless the latter is dead, outside the Philippines, or otherwise unable to testify. Okay? So basically, before the trial proper, if there is a petition for bail filed by the accused, uunahin yun ng court, okay? And the prosecution has to show that yung evidence ng guilt ng accused is that strong to deny the application for bail, okay? So during that hearing, during the bail hearing, sabi dito sa section 8, it will also be considered as part or it will be reproduced at the trial, okay? Pero it doesn't mean na precluded na yung prosecution from or the parties from calling additional witnesses or any witness to that effect, okay? Meron pa din silang right to call additional witnesses or to call the witness during the presentation or during the bail hearing, okay? For further questioning. So, yan lang yung tandaan nyo, okay? So remember also that di ba, yung imposition ng death now is prohibited under RA 9346, okay? This was enacted in 2006. And in lieu of the death penalty, the following shall be imposed. Yun na yung reclusion perpetua para sa mga violations under the RPC and life imprisonment for those violations na does not make use of the nomenclatures of the penalties of the revised penal code. Okay, I hope that's clear. Now, amount of bail, what are the guidelines? Ito yung mga guidelines, isa-isahin nyo na lang yan. Financial ability, nature and circumstance of the offense, the penalty of the offense charge, character and reputation of the accused, age and health of the accused, weight of the evidence, probability of the accused, the forfeiture of the other bail, the fact that the accused was a fugitive from justice when arrested, and dependency of the other cases where the accused is on bail. Remember that excessive bail shall not be required. Okay? So, yun, earlier we were wondering ano ba yung mga corporate surety na yan, property bond na yan. So, if you will opt for a surety, ang corporate surety is any domestic or foreign corporation licensed as a surety in accordance with the law and currently authorized to act as such. It may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. Pwede ka ding mag-post ng bail in a form of property bond, okay? A property bond is an undertaking constituted as lien in the real property given as security for the amount of bail. Wala kang pera pero meron kang properties. You can use your property as a form of bail. Okay, so within 10 days after the approval of the bond, the accused shall cause the annotation of the lien in the certificate of title on file with the register of deeds if the land is registered. So kung unregistered, doon sa registry book ng register of deeds. Okay. Okay, so I think that can still be understood. We'll now proceed to section 12. Okay, so what are the qualifications of sureties in property bond? I think this is a matter of reading, so just read this one, okay? And then deposit of cash as bail. Okay, ito. The accused or any person acting in his behalf may deposit in cash. Ito yung tinatawag nating cash bail, okay? With the nearest collector, internal revenue, or provincial, city, or municipal treasurer, the amount of bail fixed by the court or recommended by the prosecutor who investigated or filed the case. Upon submission of a proper certificate of deposit and a written undertaking showing compliance with the requirements under the rules, the accused shall be discharged from custody. The money deposited shall be considered as bail and applied to the payment of fine and cost, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Okay? Yan yung cash bail. Now let's go to the recognizance. Whenever allowed by law or these rules, the court may release a person in custody to his own recognizance or that of the responsible person. Itong recognizance, you will be released not because you posted a cash bail, property bond, or surety bond, but because there is someone who vouched for you, okay? So usually, hindi tatanggapin ng court yung own recognizance, but basically a responsible person. Example, yung barangay captain, councilor in your barangay. There are also some courts who will allow that you will be released on recognizance sa iyong parents if you're a minor, okay? Now, bail, kailan ba hindi required ang bail? Or when can you reduce bail? No bail shall be required when the law or these rules so provide, okay? Usually, yung mga BP 22 cases, di naman kailangan yun ng bail, okay? When a person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charge, shall be released immediately without prejudice to the continuation of the trial or the proceedings on appeal. Kasi merong instances na yung penalty imposed by law is only 30 days and the accused has been in custody for like 6 months or 60 days, for example. And if the court will know that, the accused will be released because parang na-serve na yung sentence. But this is of course without prejudice to the continuation of the trial or the proceedings on appeal. Okay? If the maximum penalty to which the accused may be sentenced is zero, he shall be released after 30 days of preventive imprisonment. A person in custody for a period equal to or more than period or more than the minimum of the principal penalty prescribed for the offense charge without application of the indeterminate sentence law or any modifying sentence shall be released on a reduced bail or in his own recognizance at the discretion of the court. Okay? Okay. So ito kung saan ipa-file yung bail, basically of course you will have to file it in the court where the case is pending, okay? And where the grant of bail is a matter of discretion or the accused seeks to be released on recognizance, the application may be filed in the court where the case is pending, okay? Whether in preliminary investigation, trial, or appeal. So any person in custody is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held, okay? And of course, notice to the prosecution, kailangan the court must give notice to the of the hearing to the prosecutor, require him to submit his recommendation for any applications of bail. And then, ayan, you will be released. Ito, a matter of reading lang ito. And then for feature of the bond. And then just cancellation of the bail. Basahin nyo lang guys. And then just this one, court supervision detainees, also matter reading. And then I just would like to emphasize this. This will be my last slide for this afternoon. Okay, additional rules under the revised guidelines for continuous trial in criminal cases. Petition for bail filed after the filing of the information shall be set for summary hearing after arraignment and pre-trial. Testimony of a witness in a petition for bail may be in the form allowed by the revised guidelines, provided that the demeanor of the witness is not essential in determining his or her credibility. Petition for bail shall be heard and resolved within a non-extendable period of 30 days from date of first hearing, except in drugs cases which should be heard or resolved within 20 calendar days, without need of any oral argument and submission of memoranda, consistent with the summary nature of the proceedings. Napakaganda nitong rules, no? Imagine the petition for bail will be resolved in 30 days, but this is not what is happening in the actual scenario in the real world. Basically, when you file for a petition for bail, it drags and so long a time na parang naabot iba yung I have a case gani na it's been 5 years, hindi pa na-resolve yung petition for bail. So that's the sad reality, okay? Yung motion for reconsideration on the resolution of petition for bail shall be resolved within a non-extendable period of 10 calendar days from the date of submission of the motion. So that's it for this afternoon. Before I say goodbye, I'd like to send a few shout outs to the commenters in my channel, no? I'd like to say hi. Taka lang, it's loading. I'd like to say hi to HD8976, to Tutorial PH556, Alexis Rin 20, Mabalantan 80, the Lonius Coltrane 3778. Thank you very much for your kind comments, everyone. And ito din si Vanessa Garing. Thank you very much. School Buddy 737. Thank you for all your kind comments. Please know, guys, that even if I am not replying on those comments, I am reading those and I really appreciate all your support for my channel. So daghan kaayong salamat. Thank you very much, everyone. See you next video. Amping.